Good afternoon. We are going to resume our session. Señor Aguilar, buenas tardes.
Good afternoon, Mr. Aguilar.
La declaración.
Good afternoon. Could you please read out the expert oath that you have in front of you? I'd be pleased to do so. I solemnly declare on my honor and conscience that my statements this afternoon will be in accordance with my sincere belief. Thank you very much.
Thank you, Mr. Chairman. Good afternoon, Mr. Aguilar. How are you?
Muy bien, gracias.
Fine, thank you.
I'm going to ask you a series of questions regarding the opinions you have expressed in your two expert reports. The first question is whether you have before you the two expert reports that you have rendered in this case.
Sí, es correcto.
Yes, that is correct.
And do you ratify the contents of both of those reports before this tribunal?
Sí.
Yes, I do, with one caveat, which is that in the first of these, I indicated as one of the sources the fiscal code, whose content, the content doesn't change the substance of the report, but it has been abolished and replaced by two other laws, or rather it was abolished by the tax code of the state procurement law. In the second report, I would ratify it, but I would note that there was erroneous cite to a proceeding in which the Republic of Guatemala brought a contentious administrative proceeding against the Confederación Deportiva Autónoma. Sorry for interrupting you. Since you're being simultaneously interpreted, if you read and when you speak, but especially when you read, you need to bear this in mind. Slower, slower. In the second report, I erroneously cited the number 379-2006 when I referred to the administrative proceeding brought by the Republic of Guatemala against the Autonomous Sports Federation. The correct number is 371-2009. Otherwise, I ratify in their entirety the two reports that I have submitted.
Thank you, Mr. Aguilar. I'd like to ask you a series of questions based on issues that have been under discussion in these proceedings. The first is there have been questions raised about the lack of governmental approval, lack of executive approval of Contract 41. Having reviewed the record, do you have any opinions as to why it is that that contract may not have been approved by the executive?
Sí.
Yes. Contract 41 was signed on 23, I don't have the exact date, but it was signed in 1999 on the 23rd of March before notary Marco Antonio Cornejo, Marroquin. And to this day, after almost 12 years, the contract wasn't approved by the Guatemalan state. This question also raises at the same time two additional questions, which are, why did Ferrovías not uphold its right to demand of the President of the Republic approval of that contract? And the third question is, in whose interest was it that that contract not be approved? And in order, I'm going to refer to the first issue. Contract 41, which refers to onerous usufruct of the railway equipment, was formalized before a independent notary, not a government notary, which meant that Ferrovias had chosen this notary, and consequently it had the obligation to pay the notary's fees and to attend to all the obligations that arise after the contract. Now, here I'd like to highlight one particularity of the law on state contracts. Article 49 of the law on state contracts or public procurement notes that all those acts and contracts in which the Guatemalan state is involved must be formalized before a government notary. The government notary is a public officer who provides services free of charge, but this notwithstanding, Article 49 of the law on public procurement also indicates that interested parties may request that a notary other than a government notary be the one to formalize the contract. Contract 41, I repeat, was not formalized by the government notary. It's important to note that this contract for usufruct of the railway equipment, at its clause number 20, provides for the obligation to register the usufruct contract in the General Property Register. Guatemala follows the system of public registry or registration of property through a public office, which is the General Property Registry, where acts and contracts that affect real property rights over real and movable property is to be registered. Specifically in the case of railways, there is a provision in the Civil Code which requires the entry in the registry of any act related to movables related to the railway. The key and important aspect of everything that I'm describing is that according to Article 1129 of the Civil Code, no authority, including the President of the Republic, no authority may receive or value or characterize a contract which, subject to registration, has not been registered. The response to the question as to why the government of Guatemala did not approve Contract 41 is because it does not appear that that contract was entered in the General Property Registry. And consequently, as there is a provision that prohibits the authorities from receiving or attending to a contract not in the property registry, it was impossible legally for the Guatemalan state to be able to approve that contract. This explains the first question. And the second, which goes to the issue as to whether Ferrovías had some legal action available to it to exercise its right to have that contract registered. In the Guatemalan Constitution, there's a provision on the right to petition under which the state or the authority must resolve within 30 days following a petition put forth pursuant to the right to petition. Ferrovías did not present a usufruct contract that was registered in the railway property registry, and nor did it remedy the situation through a right of petition. As regards the particularities associated with the fact that Ferrovías has not requested authorization nor obtained the registration, it's important to note the letters which I cited in my respective reports, which gave rise to an illegal possession of the railway equipment by Ferrovías. And particularly, I refer to the letter of 9 April 1999. In its context, that letter was directed to the overseer of Ferrovías de Guatemala, just 17 days after contract 41 of 23 March 1999 was signed. In that letter, Ferrovías asked that prior to taking possession of the railway equipment, or rather that it take possession of the railway equipment, even though it knew that the contract would not enter into force pursuant to Clause 6, until 30 days after its approval by the President of the Republic in Council of Ministers. In the letter, it is asked that the equipment be delivered to it and that it be the guarantor of their maintenance. On the 12th of April, which is to say 3 days later, and 20 days after the contract, which had not yet come into force, was signed, Ferrovías received from FEGUA the railway equipment without any provisions, public or transparent provisions having been set, such as those that had been undertaken in Contract 41. It was not until the 16th of February 2000 that Ferrovías insisted that the authorization outside of the framework of the contract for the use of the equipment be maintained. And without there being any particular methodology, it paid the sum of 7,500 quetzales for the use of the equipment in a proportion that assigned that value for the use of equipment in the month of January 2000.
In that letter, key conditions are changed of Contract 41, and it is stated that payments would be carried out monthly. Ferrovías overseer in the letter dated February 25th, 2000, ratified the authorization for the use of equipment and accepted for payments to be done monthly. In August 2002, Ferrovías is requested to pay the amounts that they were asked to pay but that were never paid up to August 12, 2003.
Answer. Per rules set by the tribunal and accepted by the parties, we only had 15 minutes to have questions and answers, and I'm told I only have a minute or so left. So I think, and I assume you're going to be asked questions about the issue that you were just testifying about when the tribunal and opposing counsel have an opportunity to ask you questions. I wanted to ask you an additional question, which is, to your understanding, and if you could try to limit your response to no more than, a minute, so that we're within our time frame. To your understanding, would the President of Guatemala incur in any personal liability if he had not proceeded with the declaration of lesividad in relation to contract 143 and 158 when that issue was presented to him by his legal advisors within the Secretary General's office of the Presidency?
Absolutely.
There was absolutely liability, and also the President had the obligation to declare lesividad because of the simple reason that because of the separation of power as stated in Guatemala, the declaration of lesividad only refers to declaring that there is a damage which cannot be judged or assessed by the President, since the only ones to do so are the court or the judicial system. And if he had decided upon his own discretion not to declare lesividad, he would have caused a problem with the jurisdiction, and because of his powers he had to declare lesividad, because otherwise, based on Articles 153 and 154 of the Constitution, he would have had personal liability.
Further questions at this time?
Mr. Stern?
Thank you, Mr. President. Good afternoon, Mr. Aguilar.
Buenas tardes.
Good afternoon.
In your direct testimony in response to Mr. Orta's question, you testified that you attempted to explain why you believe the President never approved Contract 41. But you never spoke with President Arzu and asked him why he never approved Contract 41, correct?
No tenía.
I didn't have any need to talk to him because I am resorting to the Civil Code, and the Civil Code of Guatemala demands for a contract to be qualified by the authority to be recorded in the property registry.
Okay, but, well, first of all, in answering my questions, I would just ask that you please try to answer my questions as concisely as possible, since I have a limited amount of time to ask you questions. I appreciate that. And again, just to be clear, you did not speak with President Arzu. I understand you say you didn't have a reason to, but you never spoke to President Arzu and had him explain to you why he never approved Contract 41, correct?
no hablé con el presidente.
I did not talk to President Arthur, and I didn't have a need to do so because my analysis is based on the laws of Guatemala, and the laws of Guatemala, from a practical standpoint, determine that no authority can examine or assess a contract when it is not recorded in the property registry.
All right, let me ask you some questions about your response to the second question Mr. Orta asked you regarding the president's legal liability if he doesn't declare a contract with Cividad. In paragraph 37 of your first report, do you have that in front of you?
Sí.
Yes.
Okay. And it's there in your first report on paragraph 37 is where you state that the president would have incurred personal legal liability if he had not declared contracts 143 and 158 lesivo before the 3-year deadline of August 25th, 2006, correct?
Sí, es correcto.
That is correct.
And in other words, it's your opinion that once the president had been advised by his lawyers and advisors that they considered contracts 143 and 158 lesivo, the president and his cabinet ministers had absolutely no discretion under Guatemalan law to refuse to issue the declaration of lesividad, correct?
Es correcto.
That is correct.
Okay, and in paragraph 37 of your first report, you cite as the basis for that opinion in footnote 24, Articles 153 and 154 of the Constitution and Article 16 of the Law of the Executive, correct?
Sí, es correcto.
That is correct.
Okay, could you now turn into the binder that you have to RL 70, and that is on tab 18 of that binder? Do you have that, sir?
Sí, pero es la constitución política.
Yes, but this is the political constitution of the republic, correct?
Oh, I'm sorry. I apologize. Tab 18? Is that correct? Yeah. Where is mine? Well, let me ask you this way. You can tell me if I'm wrong. Isn't it true that Article 153 of the Guatemalan Constitution states that the rule of law extends to all persons in the territory of the Republic?
Por alguna razón que desconozco.
For some reason that I do not know, that rule is not at this tab, but basically it is about the rules that govern the responsibility of public officials, saying that they are not above the law and that they are subject to liability. But that is not here. That is not at this tab.
apologize. There's been an error in that regard. I apologize. Okay, and correct me if I'm wrong. Is it your understanding that Article 154 of the Constitution states that government employees are vested with the authority legally responsible for their official conduct, subject to the law and never above it?
Es cor-
Yes, that is correct. It implies that no one, including the authority, is above the law. Therefore, they are responsible for all of their actions that could be against the law.
So there's nothing in that article which states that the president is subject to personal liability if he fails to declare a contract with CIVO once he's been so advised, correct?
No, that is not correct. The concept of lesividad is linked in this law to the damage or harm caused, as stated in the Spanish dictionary. The President of the Republic, as an official who heads the executive, and that's the reason why I also cited Article 16 of the executive law of the executive, states that he should act according to the law. And also in the Declaration of Lesividad, the actions, the legal actions to repair damages are intended to be started. Otherwise, he would be impeached, as stated by the courts, and the courts would be the ones determining the declaration or the legal aspect of the declaration.
Only that Article 154 provides for all of that what you just testified to, that if the president doesn't declare lesivo upon being so advised by his advisors, that those are the consequences. Is that your testimony?
Lo que estoy diciendo.
What I'm saying is that the rule applies to all public officials, authorities. The president has the power, and he is responsible from the legal point of view for the acts carried out against the law. And when there are opinions that indicate that there is any harm to the interests of the state, the president cannot qualify whether such harm was real or not. That is, he is the executive, he represents the executive, he heads the executive. Therefore, he should move on to a claim, and it would be the court the one determining whether there was harm or not.
Are you aware of any precedent in Guatemalan law, legal opinions, court decisions, anything in which a president has been charged with personal legal liability for not issuing a declaration of lesividad once so advised by his legal advisors?
No, no conozco.
No, I don't know of any situation like that.
Okay, so as far as you know, it's never happened once in Guatemala, correct?
Creo que es diferente el que yo conozca o no una situación.
I think it is different, the fact that I may not know of a situation, and this is different from this actually not happening.
Certainly in rendering your opinion here, you didn't find anything, right?
Nunca la cité.
I never quoted it, and it was not the subject matter of my opinion.
All right. Let me change topics here. It's your opinion, Mr. Aguilar, that contracts 143 and 158 were absolutely null and void under Guatemalan law, correct?
Es correcto.
That is correct.
And if, in fact, you wrote in paragraph 43 of your second report, quote, contract 143-158 is not even a valid contract. It is a non-existing contract because it never fulfilled the requirements under Guatemalan law to legally exist. Did I read that correctly? Paragraph 43 of your second report?
Sí, sí, es correcto.
Yes, it is correct.
Okay, could you, now, in connection with rendering your expert opinions in this case, you reviewed all of the prior legal opinions that the government rendered and obtained regarding contracts 143 and 158, didn't you?
Sí,
Yes.
Okay, could you turn to Exhibit C-106, which is tab 9 in your binder? Do you have that there?
sí, me imagino que ese,
Yes, I imagine it is the request by Oscar Gramajo. Is that correct?
From June 22nd, 2005, from FEGWA Overseer Dr. Gramajo to the Attorney General's Office requesting a legal opinion regarding contracts 143 and 158, correct?
sí, es correcto.
Yes, it is correct.
And if you now could turn to tab 10, which is Exhibit C-107. And Exhibit C-107 is a June 28th, 2005 letter from the Attorney General's Office to FEGWA, in which it returned the case file to Dr. Gramajo and requested further information requested further information on the status of contract 143, which it said was necessary for it to render its opinion, correct?
Sí, es correcto.
Yes, that is correct.
And among the questions the Attorney General's asked FEGWA in this document here were, one, whether contract 143 was currently effective or not, correct?
Sí, es correcto.
That is correct.
And another question they asked was, what was the total amount of fees paid by Ferrovias to the state under the terms of contract 143, correct?
Sí, es,
Yes.
And another question they asked was whether Ferrovias had complied with making the fee payments or not, and whether those payments were timely, correct?
sí, es correcto. Eso,
Correct. That's the question.
Okay, now please turn to tab 11.
sí,
Yes.
And tab 11 is Exhibit C-108, and this was FEGWA's July 18th, 2000 response to the Attorney General's inquiry, correct?
por favor, ¿me puede citar la?
Would you please say the date again?
Sure. If you look on the second page of the
Okay.
the note or the letter from Dr.
Yeah.
Gramajo, July 18th, 2005, you see that?
Sí, ya la vi, es correcto.
Yes, I saw it. It's correct.
And Dr. Gramajo attached to his letter a July 15th, 2005 opinion from FEGWA's legal department, correct?
Sí, correcto.
Correct.
And you're familiar with this opinion, right? You reviewed it and understood it in providing your opinions in this case, correct?
Es correcto.
Correct.
Now, in this opinion, in Exhibit C-108, in response to the Attorney General's question on whether Contract 143 was currently effective, this opinion states, quote, the contract involving railway equipment entered into with Codife on August 28, 2003, as documented by Public Instrument Number 143, as amended by Contract 158, both authorized by Claudia Mariela Marroquin Luther, Notary, is currently in effect. So here, FEGWA's legal department, in response to a request from the Attorney General's office regarding contracts 143 and 158, acknowledged that those contracts were currently in effect, correct?
Sí.
Yes.
And also, at the end of this paragraph I just quoted, it says, accordingly, the contract relevant to FEGWA's petition to the Solicitor General's office is documented by Public Instrument Number 143, which is currently in effect. It is also under the terms of this contract that the usufructuary is using the railway equipment. Correct? Did I read that right?
Yes, you read it correctly.
So here, FEGWA's legal department certainly didn't think that Contract 143 was null and void, did it?
No.
I think that here the issue has to do with the terms used. Article 1301 of the Civil Code states that contracts that are null do not have a legal effect. So we need to make a difference between the legal effect from the practical implementation of contracts that are null. And this contract is null. And just to give you an example, they changed the canon, the payment for the use of equipment from 1%, that was the originally amount that was agreed based on net invoicing, to 1.20, from gross invoicing to net invoicing 1.25% after the deduction of taxes. And indeed, 143, Ferrovias exempted itself from the payment of taxes and also reduced the canon due to the payment of the use, due to the payment owed.
I don't think that what your answer here is responsive to my question, so I'm going to move on, okay?
Absolutamente tiene que ver.
There is a connection here because we are referring to the implementation and to the legal effect. What I wrote at clause 43 of my opinion is that based on Guatemalan law, a contract that is null does not have a legal effect. But you're asking me here, and you're asking me to see here, that a contract was implemented, and that contract was and is against the Guatemalan laws, and therefore it is null. We are referring to implementation, which is quite different from legal effect. What I wrote in my opinion is that based on the law, a contract that is null does not have a legal effect, and I ratify this.
If I understand your testimony, are you saying that here FEGWA's legal department, their lawyers, were not telling the Attorney General, the top legal officer in the country, that Contract 143 was currently in effect, legally in effect? Is that what you're telling us?
Le estaban diciendo que estaba.
They were saying that it was being implemented, that it could have effects, but not legal effects, because legal effects are not recognized in the Civil Code at Article 1301, and that is what I wrote in my opinion.
In here, it doesn't say anything about implementation, does it?
¿En cuál dictamen?
In what opinion? My opinion?
The FEGWA legal opinion we've been talking about, sir.
El dictamen.
The opinion was about facts. It was not a legal opinion. They were doing what it was agreed, and they are saying, yes, this is being complied with, it is being implemented, but it does not mean that the contract is a valid contract. The contract is null because it went against key laws of the Guatemalan state.
it's your testimony that this document, Exhibit C-108, this legal opinion, this opinion from FEGWA's legal department is not stating that Contract 143 is legally in effect. Is that your testimony?
The question's been asked and answered now a couple of times. I think we can move on.
Okay, I'll move on. Well, you would agree that an absolutely null and void contract under Guatemala law cannot be in effect, correct?
Totalmente de acuerdo.
I totally agree. It cannot have any effect, but it cannot be ratified either.
Opinion that Exhibit C-108, the FEGWA legal opinion, is wrong?
No,
The legal opinion by FEGWA is not a legal opinion on the contract. Rather, it refers to a factual relationship that has to do with the implementation of something that was agreed in a contract which is null. It is very different from saying that this was a legal contract on the validity or not of the contract.
Now, this opinion also acknowledges to the Attorney General of Guatemala that Ferrovias had paid FEGWA to date $817,000 in canon fees for use of the FEGWA equipment. Correct?
Sorry, could you just
Yes,
could
sir.
you just clarify that that's Quetzales?
Yeah, I'm sorry. Let me state it again. Now, this opinion, it also acknowledges that Ferrovias had paid FEGWA to date $596,817,000 quetzales in canon fees for use of the FEGWA equipment, which included the fees Ferrovias had paid pursuant to the terms of Contract 41, correct?
Quiero aclarar.
I'd like to clarify something because this is something very important. Ferrovias paid on February 20th, 2000, 7,500.
This had to do with what the opinion states.
Yes.
In his question, pursuant to Contract 41, and the witness is responding directly to that portion of the question. Now, Mr. Stern may not like what he's going to hear, but he should be allowed to respond, the expert.
Or he may correct the answer if he made a mistake.
He's cutting him off when the witness was answering directly the question that was posed to him. He in his question said that FEGWA received payments pursuant to Contract 41, and the witness is responding to that.
Por favor, termine de responder.
Please complete your answer. I would like to state that Ferrovias acquired the control of the equipment and paid 7,500 quetzales in January 20th, 2000, and used the equipment for free during 2000, 2001, and August 2003 for only 7,500 quetzales. They received two letters requesting payment sent by FEGWA on August 23rd, 2002, and they failed to pay. And whatever they paid it as a change in the conditions that introduced in Contract 143 by changing the calculation basis from gross invoicing to net invoicing and excluding the payment of taxes. That's the reason why I said that in that contract they granted themselves tax benefits, because they changed the basis for the calculation, and that is something that is against the laws of the country and that renders that contract null.
Okay, I'm going to just read the last sentence of the opinion under the heading regarding subsection B. It says, quote, as a result, up to December 31st, 2004, the state of Guatemala, through FEGWA, has received from the usufructuary the total of 596,817 quetzales and 87 cents as payment of fees for the use of railway equipment. Did I read that correctly?
Sí, lo leyó bien.
Yes, you read it correctly.
In subsection C of this opinion, FEGWA further acknowledges that Ferrovias was up to date in the payment of canon fees for use of the railway equipment, correct?
The letters that I cited of August 2002 show otherwise. Ferrovia was collected the money several times, but it wasn't updated.
Okay, but this is from July of 2005. Do you have any reason to disagree with the statement here, in the opinion that Ferrovias was up to date in its payment of canon fees for the equipment?
Yes, of course, because the payment is the fulfillment of an obligation, and the obligation was actually denatured because they went from a gross invoice to a net invoice.
Is it proper under Guatemalan law for the government to accept performance and benefits under a contract that is determined to be null and void and of no effect?
In my opinion, specifically, I said that when Guatemala required the lesividad of the contracts in the petition of the court ruling and under Article 1312 of the Code of Guatemala, the state of Guatemala surrendered back to Ferrovias the amounts of monies that were incorrectly and illegally awarded to it, because the effect of the null and void nature of this situation is for things to go back to the original status. And this is a petition that was put forth to the tribunals, where the state of Guatemala, because of the fact that this was a null and void contract, was asked to surrender the monies that it got from Ferrovias.
I'm not sure you answered my question. You talked about some filing that's been made in the court. My question was, again, is it proper under Guatemalan law
Claro.
for the government to accept performance and benefits under a contract?
Could you please repeat the question and go a little slower, please? I'm not able to interpret at this rapid pace. I'm sorry, sir.
Okay. Is it proper under Guatemalan law for the government to accept performance and benefits under a contract that it has determined to be null, void, and of no effect?
The government did not accept to benefit from that contract, and as a consequence of lesividad, and on a basis, and I repeat, on the basis of Article 1312 of the Civil Code, the government of Guatemala gave back the monies that it received under a contract that was null and void and illegal. In answer to your question, no, the state of Guatemala did not enrich itself, nor has it benefited from monies that come from a null and void contract.
Are you saying that the government of Guatemala has returned to Ferrovias the canon fees that Ferrovias paid to it under contracts 143 and 158? Is that your testimony, sir?
Look at
What I am saying to you is that in the court proceedings where the Lesivo declaration is being discussed, one of the things that the Guatemalan state required was the surrendering back of those canon fees.
Money been given back, to your knowledge? To this day, has the money been given back?
no, lo que pasa es
No. What happens is that this is a process that's going on, and the judgment has not been handed down. The surrender is done according to the laws of the country with interest.
Now, if I understand your testimony in your reports, because contracts 143 and 158 were absolutely null and void, the defects in these contracts could not be cured or resolved through negotiation between the parties, correct?
In connection with that contract specifically, 143 and 158, no. Now, in connection with the disposition and use of the property, well, the state of Guatemala, as the owner, the state of Guatemala can negotiate.
Could we just pause for 1 minute? I have to check one thing.
Excuse me, we haven't heard you.
1 minute pause.
Oh, okay. Just, we are going to stop. Vamos a parar por un minuto.
We're going to stop for 1 minute.
can continue.
Okay, let me ask this question again because I'm not sure I understood your answer. Well, let's look at paragraph 77 of your second report. You wrote here in paragraph 77, do you have that, sir?
Sí, ya lo encontré.
Yes, I found it.
By contrast, in the case of absolute nullity, the defect cannot be cured because it affects an essential requirement for the existence of the contract. In this regard, Contract 143/158 suffers from defects that cannot be cured and which emphasize the absolute nullity of the negotiation. Did I read that correctly?
Es correcto.
That is correct.
Okay, so see if I can understand your testimony. Is it your testimony that because contracts 143 and 158 were absolutely null and void, the defects in these contracts could not be cured or resolved through negotiation between the government and Ferrovías?
Los
Contracts 143 and 158 cannot be cured because they are null and void. Contracts 143 and 158. I would like to highlight this because what the government was able to negotiate was the disposition of its property by using them in the manner that the violated laws had set forth.
So if the facts were, assume that the facts were in this case that the government and people and officials from FEGWA attempted to negotiate with Ferrovías a way to cure the illegalities of Contract 143 and 158. Assume that was the facts. Would that have been, in your view, would that not be proper or possible under Guatemalan law?
As far as I understand, and I know, the government of Guatemala never negotiated the curing of the defects of 143 and 158. What the government did as the owner of the property was to negotiate the rights that it had over its property in a legal manner, something that was different from the manner in which they had been negotiated under 143 and 158. In other words, the issue was not to cure the defects of 143 and 158. Those cannot be cured. The issue was to regulate under the law the use of the equipment. This is a very important conceptual difference.
How did the parties use the equipment? How did Ferrovías use the equipment that was different from the terms of contracts 143 and 158 after the contracts were entered into in August of 2003?
Basically, as I indicated, in a letter dated 9 April 1999, Ferrovías took the equipment knowing that the contract had not been in effect, and it had them under its use and possession without an approved contract. Then it entered into 143 for onerous usufruct without bidding terms, without transparency, without public requirements that are needed for the disposition of government property. That is why I say Contract 143 and 158 cannot be cured. Neither could they be the subject of any negotiation. What can be negotiated, even today, are the provisions under which Ferrovías would have been legally able to use the equipment owned by FEGWA. That is what was on the table, not the convalidation of null and void contracts.
It's your understanding of the facts that Ferrovías, after August of 2003, when contracts 143 and 158 were entered into, they continued to use the railway equipment pursuant to the terms of the letter authorizations that were given by FEGWA back in 1999. Is that right?
Eh,
That's not exactly correct. Let's separate this issue of use. Ferrovia continued to use the equipment from 2000 after the onerous use of a contract was entered into, but it didn't do it in the same conditions that were established in contract 41. There was an exchange of letters, and there was a change in the canon fee payment from a yearly to a monthly payment. And then we went from net invoicing, from gross invoicing to net invoicing. So it continued to use the equipment, changing the conditions and doing it beside the law, because there was no transparency, the public requirement was not established, and there was no bidding terms either.
Go to a different topic. My first question on this topic is, it's your opinion, or you maintain, that contracts 143 and 158 are administrative contracts, correct?
es correcto.
That is correct.
And it is also, and it's your opinion, according to your expert opinions, that the declaration of lesividad was the only legal means available by which the government could deal with the alleged illegalities of contracts 143 and 158, correct?
Es correcto.
That is correct.
And as you point out, for instance, in paragraph 65 of your second report, the Contencioso Administrativo Court has exclusive jurisdiction over matters involving administrative contracts, correct?
Es correcto.
That is correct.
As you point out in paragraph 66 of your second report, under Article 221 of the Guatemalan Constitution, the Contencioso Administrativo Court quote, has the competence to hear disputes resulting from administrative acts or resolutions and from state decentralized and autonomous entities, as well as disputes resulting from administrative contracts and concessions, correct?
Es correcto.
That is correct.
As Article 221 states, the one I just quoted from, the Contencioso Administrativo Court doesn't just have jurisdiction over actions to confirm declarations of lesividad, correct?
Sí, es correcto.
That is correct.
The Contencioso Administrativo Court has jurisdiction over any dispute or controversy involving an administrative contract, correct?
Correcto.
Correct.
And the Contencioso Administrativo Court can hear claims by the state for breach of an administrative contract, correct?
Correcto.
Correct.
And the state doesn't have to declare a contract lesivo before bringing a breach of contract action in the administrative court, correct?
Incorrecto.
That is not correct. The state always has to promote the declaration of lesividad to then go to the Contencioso Administrativo Court. And if you want, we can go and see Article 20 of the administrative law that states that when the state sues in the administrative arena, has to put forth previously a declaration of lesivo.
If I understand your testimony, if there's been a breach of an administrative contract, the state has to declare lesivo before filing suit in the administrative court.
Es correcto.
That is correct.
Okay, let's look at Exhibit R308. Is this in his? I'm sorry. Oh, yes, it's tab 13 in your binder. Now, Exhibit R308 is a table or chart that was prepared by Guatemala in this case, which purports to state all the known declarations of lesividad actions that have been brought in Guatemala since 1991 at least. Are you familiar with this chart?
Sí, sí, tengo.
Yes, yes, I am familiar with it.
And by my count, there are 17 cases listed
17.
in this chart from 1991 to present day, correct?
Es correcto.
And these are the only
That is correct.
only known contencioso administrativo actions regarding declarations of lesividad that have been brought in Guatemala since 1991, correct?
Esta tabla se origina.
This table is based on the second opinion of Alvarado, I think.
That wasn't my question. My question is, the 17 cases that are listed here in this chart prepared by Guatemala are the only known actions brought in Guatemala before the Contencioso Administrativo Court since 1991 to confirm a declaration of lesividad, correct?
No. This table was not prepared by the state of Guatemala. This was prepared by Eduardo Mayor Alvarado in his witness statement. On the basis of this table, we analyzed the status of these proceedings. So I cannot say that these are the only ones. I cited the ones that Eduardo Mayora included in his statement.
Are you aware of any other cases besides the ones listed in here?
I don't know. No. What we were doing was to cite each one of the cases in the way in which Eduardo Mayora cited them in his opinion.
No tratábamos.
The purpose of the state of Guatemala was not to say that these were the only ones. We only used as a basis the ones that Eduardo Mayora included in his opinion.
So you didn't make any effort whatsoever after seeing Dr. Mayor's chart to find out if there were any additional lesividad actions that have been brought since 1991. Is that what you're telling us?
No era.
That was not the thing that I was asked to opine on. I was asked to opine on the opinion of Mr. Mayora. Mr. Mayora is the one who prepared this table. In my legal opinion, the purpose was not to establish whether we had some, many, or a lot of these cases. It had to do with opining on Eduardo Mayor's opinion.
And well, is it your understanding or belief that there are a lot of other lesivo cases that have been brought in the last 20 years?
No,
I don't think so. And that speaks highly of the state of Guatemala.
Again, based on your testimony that in order to bring a breach of contract action, the government to bring a breach of contract action in the Contencioso Administrativo Court, they have to declare lesividad, right?
sí.
Yes. My basis is Article 20 of the Administrative Law, which provides the requirements for the parties to bring a case before the administrative court. The state of Guatemala has to have a previous declaration of lesividad related to the act or contract that is going to sue under.
And so, is it your understanding that the cases that are listed in Exhibit R308, and perhaps a few more that you weren't able to, didn't look for, are the only cases in the last breach of contract, any contract actions relating to administrative contract have been brought by the government in Guatemala in the last 20 years? Is that what you're telling us?
What Eduardo Mayor is saying in his opinion is that the administrative proceedings do not end in Guatemala. the proceedings are excessively long, and almost none of them reach a decision against the interests of the state of Guatemala. The disputed issue was that, and we did a study of the cases he presented, and we showed that in one of them there was a case against the state of Guatemala, and that judgment had already been handed down at the date Mayora had issued his opinion. We wanted to underscore the fact that the state of Guatemala respects the Court of Justice, and that it can also lose in cases such as this, where the case analyzed where there was enough juridical basis for the harm. In the case that we cited, the state of Guatemala lost the action in the administrative court, and we also added another column that is called current state of the process, to show that some of these cases had been terminated because the judgment had been handed down, or because the parties had decided to dismiss the case, and it had nothing to do with the delay indicated by Mayor in his opinion. He was trying to show that the state of Guatemala was completely inefficient in these kinds of disputes.
Then, in Exhibit R308, it's true, is it not, that there are only 2 cases of the 17 that are listed here in which the administrative court reached a final decision, correct?
Sí.
Yes, that is correct. You can also see that there are cases that ended there because of negotiation.
That in which the court actually reached a decision, correct?
Es correcto.
That is correct. And that impairs the state of Guatemala.
And in one of the cases, of the 2 cases, one of them, the court did rule in favor of the state of Guatemala, correct? The earlier one.
Ajá.
Is that a yes?
Dijo,
Sí, sí.
yes, yes. En los últimos 20 años.
Last 20 years, you were only aware of 2 cases in which a declaration of lesividad has been brought, in which the court, the administrative court, has reached a final decision, correct?
On the basis of Mayores's report, yes. I am basing my answer on Mayores's report. That's correct.
And you're not aware of any other cases, isn't that right, sir?
No, no era ese el motivo.
That was not the purpose of my opinion. I don't know. I don't have that in mind. Yes. Basically, I repeat. Eduardo Mayora included this in his opinion. We updated Mayores's opinion, showing issues that he had not shown. So what we did is include the ending of proceedings and the handing down of final judgments. And it wasn't true that there was a delay and the proceedings were not terminated.
Okay. Now, if the state wishes to nullify an administrative contract, well, let me ask you this question. Under Guatemala law, you would agree that there's no statute of limitations for bringing a legal action for absolute nullity of a contract, correct?
Es correcto.
That is correct.
It's Civil Code Article 1301, correct?
Es correcto.
That is correct.
And then Article 1302 of the Civil Code also provides that evident nullity can be declared ex officio by the court. Nullity can also be alleged by the interested parties of the Attorney General's office, correct?
Es correcto.
That is correct.
So the Civil Code, the Guatemalan Civil Code, provides that an action for absolute nullity can be brought at any time by not only one of the parties to the contract, but also by the Attorney General on behalf of one of the parties, correct?
Es correcto.
That is correct.
And the Attorney General can bring such a nullification action even for non-administrative contracts where both parties to the contract are private parties.
Es correcto.
That is correct.
And again, under the Guatemalan Civil Code, the Attorney General could bring such a nullification action at any time, including, for example, 10 years after the contract was first executed, correct? Contract involving private parties.
Perhaps it's a question of terminology. I wanted to clarify something. When you're talking about annulment, we're talking about relative nullity.
Asking you about absolute nullity, the situation you claim existed with contracts 143. So let me ask the question again, okay? Assuming for an action for absolute nullity, under Guatemalan law, the Attorney General can bring such an action at any time where the contract involves private parties.
Es correcto.
Okay.
That is correct.
So the Attorney General could bring an action for absolute nullity of a contract involving private parties 10 years after the contract was first executed, correct?
Sí, nunca.
Yes, they never have any effects, no, nor are they revalidated.
20 years after, as long as the contract's still ongoing, it could be 20 years, correct?
Está.
Are we talking about absolute nullity? Yes, they produce no effects.
Okay, now, under Guatemalan law, a lesividad declaration against an administrative contract must issue no later than 3 years after the execution of the contract, correct?
Es correcto.
And
That is correct.
under Guatemalan law, if the president fails to issue the lesiva decree within that prescribed 3-year time frame, the state loses forever any opportunity to declare the administrative contract lesivo, correct?
Basically, I feel that I know where your question is headed. It has to do with the nature of the civil administrative contract.
That's where I'm heading. You can just answer
Está
my
bien.
questions. So the answer is correct, right?
¿En qué sentido?
In what sense?
This question again. If the president fails to issue a lesivo declaration within the prescribed 3-year time frame, the state loses forever any opportunity to declare the administrative contract lesivo, correct?
Depende de la naturaleza.
It depends on the nature of the harm. Yes, because Article 23 of the Law on Administrative Procedure sets 3 years for declaring lesividad.
So, for example, assume in the present case involving contract 143, the grounds for absolute nullity of that contract were not discovered by the government until September of 2006. Under Guatemalan law, the government would not have been able to seek nullification of that contract because the 3 years had passed from the entering into that contract, correct?
I'm sorry, I'm going to object. You're misstating the facts and evidence in terms of when the government discovered the grounds for lesivo.
Well,
In your question. I don't know if you meant that as a hypothetical.
Yes,
you stated it as a
yes,
fact.
this is a hypothetical. I said, for example.
Well, I think you should restate the question then, because that's not how it
All right,
reads.
I will add the words assume to my hypothetical here. So, Mr. Aguilar, assume for me that in the present case, the grounds for absolute nullity of contract 143 were not discovered by the government until September 2006. Do you understand what I'm saying? Do you understand that assumption?
Mire, le entiendo, está ocurriendo.
I do understand. Something's happening with interpretation because I understand that you are referring to absolute nullity, but in the interpretation I'm hearing the term anulación, and anulación is not the same as absolute nullity. So it's likely that we might be missing out on a connection between the question and the answer because of that.
I don't know the translation, so I apologize for that. But let's be clear, in this assumption, we're talking about grounds for absolute nullity in all my questions.
Okay.
Okay? So, assume again that in September 2006, the government discovered grounds for absolute nullity of contract 143. Do you understand that assumption?
Sí,
Yes, I do. Now, look, I know where you're headed.
Let me ask
Okay.
my questions. Now, if I understand your opinions and testimony under Guatemalan law, under that assumption, that factual assumption, the government would have been unable to seek the nullification of that contract because the 3-year time period to declare lesividad had already passed, correct?
No,
No, if you give me an opportunity to explain, then I would be most thankful.
estamos
We're talking about personal liability of the president, and we're talking about a term of 3 years that he has to declare lesividad. If the president does not act within those 3 years, then he incurs personal liability. Under the theory of absolute nullity, even if he had not made the declaration within the 3 years, that does not imply that he would not be able to seek absolute nullity, because the contract, as we've been saying from the outset, cannot have legal effects. And a contract which is absolutely null is not going to be revalidated by the fact that there was a failure to declare lesividad within 3 years. What is noteworthy is that there is someone responsible who did not make that declaration. That person with responsibility is called President of the Republic. But not because of that will an absolutely null contract be revalidated because of an omission. That's what I want to point out. I've always noted that the President had the obligation to issue the Declaration of Lesividad because it was an act which was under his responsibility within the period of the law and during his presidency. A bit slower. Excuse me. So, from where should I repeat? It's a question of separating. You don't need to repeat anything, just to bear that in mind. But basically, the fact is, the President of the Republic is liable if he doesn't issue a declaration of lesividad within the framework indicated by law. But the fact that he doesn't make an absolutely null act, or doesn't validate an absolutely null act. That's my answer.
Are you saying that the President could have issued the Declaration of Lesividad against Contracts 143 and 158 after the 3-year statute of limitations?
es correcto, pero ya
That is correct, but he would have already incurred liability. What the Attorney General would have done, and as you said specifically, was bring an action and seek absolute nullity, because otherwise it wouldn't make any sense for the legal order to note that a contract is absolutely null and has no legal effect if the fact that there was no declaration of lesividad could give it legal life. We are, in my opinion, highlighting that the President of the Republic had an obligation and liability if he did not do so within the 3-year period.
So, if I understand your testimony, the only reason the President Berger had to declare Contracts 143 and 158 lesivo by August 25th, 2006 was to protect him against personal legal liability. Is that your testimony?
No, not at all. His responsibility is to execute, as the head of the executive, all those actions that tend to uphold the rights of the Guatemalan state. And here, basically, a question of vindicating the property rights of those who had them improperly, as was the case of Ferrovias, which had equipment that had not been granted and delivered as mandated by the country's law.
So if the President declared lesividad on August 26, 2006, he would have been subject to personal legal liability. Is that your testimony?
es correcto.
That is correct. Had he not made that declaration,
But he could have done it, right? Is that what you're saying? He could declare lesividad.
No.
He could declare lesividad on August 26, 2006. Is that what you're saying?
No, él tenía la
no, he had the responsibility to do so before the 3 years had elapsed.
About the responsibility, but I'm just saying whether. Okay, I understand your testimony about his responsibility to do so by August 25th. My question was whether he had the power and the right to declare lesividad on August 26, 2006.
no
No, because the law says that the declaration should occur within 3 years.
Do it within 3 years, right? Because I thought you said he could do it afterwards, just a little while ago. It's just he would be subject to
Claro.
personal legal liability if he did it afterwards. Is that not what you're saying?
No, no es lo que...
No, that's not what I'm saying. What I'm saying is what the law says, and if we refer to it, I think that will clear up the doubt very much. Article 20 and 23 speak exactly of the time period within which the declaration of lesividad should take place, or must take place.
Let me just make sure I'm clear so the tribunal can understand what you're telling us. Could the president declare lesividad against contracts 143 and 158 after August 25th, 2006? It's a simple question, sir.
No, no podía.
No, he couldn't, because the law clearly states what the term is. Let me clarify. The date that you're telling me is after the 3 years?
Ok, no podía.
Okay, he couldn't. Now, that doesn't mean that the contract would become valid. What the Office of the Attorney General would have to have done there in representation of the state was to initiate an action of liability for not having initiated the action within the legal term, and to bring an action to seek the absolute nullity of a contract that could not have effects. But that's not what happened. And what President Berger did was what the law mandated, which was that he produced the declaration within the 3-year period.
Be done. So, if the president could not declare lesivo after August 25th, 2006, and the only means by which, according to your opinion, the state can seek the absolute nullification of an administrative contract is through a declaration of lesividad, how is it possible that the government, the state, could seek the absolute nullification of contracts 143 and 158 after August 25th, 2006?
Básicamente,
Basically, based on the legal principle that one cannot revalidate or confirm such contracts, nor can such contracts have any legal effect. So what the state does is to say, Mr. President, you did not comply with your responsibility. But the contract, which was not declared lesivo, is absolutely null, and one can follow that avenue based on certain principles of law. And I can cite the case of Costa Rica, where, according to Costa Rican legislation, one can declare absolute nullity of a contract even though it has not been declared lesivo, because there is no principle for confirming acts that are against the law.
Mr. Horta.
Thank you, Mr. Chairman. Just for the record, we're putting up RL 72, which is the Article 20 that Mr. Aguilar has been referencing. Okay, so I'm informed that we only have the Spanish version of the document, so I'm going to put it up and ask the witness to read it, and then that'll produce an English translation. I apologize, we don't have the English translation of this article. We can't supply it to the tribunal.
básicamente,
Hold on 1 second, Mr. Aguilar. Okay, so you said that, if I understood your testimony correctly, you said that pursuant to this Article 20, the government had to declare lesivo the equipment contract 143 and 158 in order to have it declared null and void. Is that correct?
es correcto.
And can you tell us
That is correct.
in this Article 20 you're basing that opinion?
En el párrafo último.
It's the last paragraph.
Record, because we don't have an English translation, so if you read it into the record, then the arbitrators will see the English translation and will be able to then follow the text, please.
Eh,
Well, that's a good point. If you could please read it into the record and then
ok.
provide your answer.
El párrafo último dice así.
The last paragraph reads as follows. If the proceeding is brought by the administration for its acts or resolutions, it will not be necessary for the requirements indicated to be met so long as the act or resolution has been declared lesivo or harmful to the interests of the state in an executive resolution issued by the President of the Republic in Council of Ministers. This declaration may only be made within 3 years following the date of the resolution or act that gives rise to it.
Bajo esta norma,
Under this provision, I indicated that the Guatemalan state has to issue a declaration of lesividad, and it is issued by the President of the Republic in Council of Ministers. And that is why I noted that it is a responsibility of the President not to issue it, or to issue it within the 3-year period following the resolution, as indicated by the last paragraph of Article 20, which I've just read out.
Okay. So if President Berger had not declared the contract lesivo, the contract at issue 143 and 158, within the 3-year period referenced in Article 20, are you saying that there was an ability for the government to nonetheless challenge that contract after that date?
es correcto.
That is right. What was on the table for discussion was whether President Berger had an obligation or did not have an obligation to issue the declaration, and if he would incur liability for not doing so. That is why I invoked Article 20, because it notes specifically that it's the President of the Republic in Council of Ministers who is responsible for issuing the declaration within 3 years. That's part one of my answer. Part two, which is where we are following the whole issue of whether it was absolute nullity and whether it was could be revalidated. The fact that that declaration is not made does not give legal life to, nor does it revalidate contracts that are absolutely null. And there are legal avenues for seeking a declaration of absolute nullity, but in this case, there was personal responsibility for the President.
You mentioned that the Attorney General would be able to bring an action to declare the absolute nullity of the contract even after the 3-year period. But before what court would that action be raised?
De acuerdo con el artículo 400,
According to Article 462 of the Civil Code, property that is owned by the Guatemalan state is governed by special laws. In this case, the dispute has to do with a contract that has to do with goods that are state property. Article 221 of the Constitution says that the Contentious Administrative Court is the only court with jurisdiction to hear such disputes. And Guatemalan civil law that applies on a subsidiary in a subsidiary manner goes beyond the Attorney General of the nation, because it indicates that any person who has an interest can bring a suit seeking a declaration of absolute nullity of a contract. And in this case, the court with jurisdiction is the administrative court.
I want to ask you about a different topic that you were asked about. Mr. Stern asked you whether it would be possible through a settlement to revalidate or to cure to revalidate contracts 143 and 158. And I believe you answered to his question that that would be impossible.
Es correcto.
That is correct.
Would that mean, in your opinion, that it would be impossible for the president to give approval, his approval through an executive resolution to that agreement, 143 and 158?
Sí.
Yes, it is impossible, legally speaking, for him to have done so because that contract originated in violation of the statutes that regulate state-owned property, specifically in violation of Article 89 of the law on government or public procurement.
The government and Ferrovías have entered into a settlement whereby they would agree to, by way of example, celebrate a new public bid and enter into a new and separate contract that was not lesivo to the interests of the state?
Sí.
Yes. Of course, they could negotiate, and they can negotiate, because the ownership of the assets that are of the government and that it can dispose of are separate from the way in which contracts 143 and 158 were drawn up. But the Guatemalan state and Ferrovías could negotiate, re-establishing the legality of the use of the equipment.
Is that something that they could have done after the president signed the executive resolution of lesividad, but before he published the executive resolution?
Podían hacerlo.
They could do it before and after, just as they could do it now, today, because the Declaration of Lesividad refers to contracts 143 and 158. But that doesn't stand in the way of the state negotiating with respect to those assets and their use becoming regularized in terms of legality.
Sir, on what basis do you contend that the president or that the administrative court has an ability to determine that an administrative contract such as this one, 143 and 158, is or is not lesivo, or does not cause lesion to the interests of the state?
I'm going to object as beyond the scope of his cross-examination. I didn't ask him any questions about this.
The witness should answer.
La base legal es el artículo.
The legal basis is Article 221 of the Constitution of Guatemala, which establishes that the contentious administrative court has jurisdiction to hear issues having to do with the legality of acts of the public administration, and specifically disputes having to do with administrative acts or resolutions.
The last question.
Thank you. Just my last question. Is the issue of injury injury to the state, is that defined in any way under Guatemalan law, in your opinion?
Sí, sí, está definido.
Yes, it is defined. Article 10 of the law on the judiciary indicates that the words of the law should be interpreted in keeping with the Dictionary of the Spanish Royal Academy. La lesividad, as defined in the Dictionary of the Spanish Royal Academy, comes from Latin lesium, which means harm or prejudice. And the definition of damages is specified in Article 1434 of the Civil Code, where it indicates that harm is a detriment or property-related loss, and prejudice is a lawful gain that is not received because of a harm. So there is a definition of the Guatemalan legal order.
My understanding, Mr. Aguilar, is that the government submits that one of the defects in contracts 143 and 158 is that it was not submitted to a public bid. Is that your understanding?
Es correcto.
That is correct.
The predecessor contract 41 was submitted to a public bid, and given that the other contracts and the use of had already been signed with Ferrovias, why is it that you would have to have yet another bid for 143 and 158?
Porque
Because, as I recounted at the beginning of my statement, Contract 41 was not entered in the General Property Registry. This requirement, because these are movables that are subject to registration, required Ferrovias to present the document for its entry in the registry, and that is why I was very specific in citing Article 1129 of the Civil Code, which notes that no authority, no court of the Republic can admit documents that are not entered or reasoned by the property registry. Consequently, Contract 41 was not approved because they never presented a document entered in the property registry. In the case of Contract 143 and 158, as they were formalized without new bidding terms, without having been public bidding, they could not be revalidated because they come up against Article 89 of the Law on Public Procurement. That is the reason why the effects of 143 and 158 could not be revived, and why, and that is why, because Contract 41 had to have been entered in the property registry. This is indicated in Clause 20 of Contract 41, where the parties accepted the obligation to enter the contract in the registry.
Whose responsibility was it to enter that in the registry? Was it a dual responsibility of FEGWA and Ferrovias, or whose responsibility is it to make that entry?
absolutamente
Absolutely of Ferrovias. That is why I cited Article 89 of the Law on Public Procurement, because in the contracts in which the state participates, the official, the notary who is responsible, is the government notary. But there's an exception. When the interested party contracts a notary who is not of the government, then this interested party is the one who assumes the responsibility for the payment of fees and for seeing to it that notarial obligations are fulfilled. The Guatemalan state did not contract a notary Cornejo Marroquin. He is an independent notary. The notary of the Guatemalan state was Byron Diaz Orellana, who was the notary who formalized Deed 402, which was registered, and all of the rights of usufruct were entered in the property registry, but this was not done with the railway equipment.
Mistake that they called a private rather than a public notary?
no, ese
No, it was a right that Ferrovias had under the law to choose the notary.
To them as to who the notary is.
básicamente
Basically, to have control over the deed, a notary who they knew and not one who was a public official of the state. Whatever the reason, what's clear is that they did choose the private notary.
Any, in a situation where, as you've described, you believe that there was a requirement for a rebid, you have an encyclopedic knowledge of the Constitution and administrative law, which is much appreciated. Is there any provision in a situation like this which allows for a no-bid contract given all these circumstances? Under the public procurement laws?
la regla
The general rule is that no. Nonetheless, there are some exceptions due to public calamity or private situations where there are natural disasters, but that or contracts between private persons and the state in the case of natural disasters, but that wasn't the case of Ferrovias, and therefore they had to abide by the requirements of Article 89.
You've mentioned that several times that there would have been personal liability on the part of the president had he not issued La Cividad, correct?
It is completely correct.
Your broad knowledge of administrative law, can you tell the tribunal if there have been any instances in which a president has been held personally responsible for failure to issue La Cividad?
I do not have previous information that I can mention here to the tribunal.
One of the issues that divides your opinion from the preceding expert is the question of what discretion the president may have when he is provided with a legal opinion from his subordinates. And if I correctly understand you, you were saying that there is no discretion on the president's part. Is that correct?
es correcto.
That is correct. And basically, I'm sorry, but because of the separation of powers as stated in Article 140 of the Constitution for the state itself, the executive
I'm sorry, please.
the executive has to execute and head or lead the executive structure of the state. They are not in charge of solving any disputes or qualifying controversial situations, but this responsibility to apply justice is in the hands of the courts, the judiciary, the Supreme Court. Therefore, the President of the Republic does not have any discretion to qualify whether an event may lead to harm or not. Otherwise, he would be taking up a responsibility that is not within his jurisdiction. He is responsible for declaring lesividad whenever harm has been identified, and then the judiciary is to qualify this because of the separation of powers. Otherwise, this would have been an action due to omission, and that would have he would have been against the law, and it's only the courts that are to determine the non-application of something. He would have been against the rule. That would have been personal liability, and in the theory of the principle, it has to do with the non-discretionary powers of the public administration.
The declaration of lesividad is not an action to be taken lightly, I assume, because you're making a finding that it's harmful to the interests of a state. That's not an everyday occurrence, correct?
Es correcto.
That is correct.
It is the President of the Republic who must issue that declaration. Is that correct?
Sí.
Yes, that is in Article 20 that I read.
And in your interpretation, the President of the Republic, in making that kind of consequential decision, is really a total functionary. I mean, he might as well be a bump on the log or a secretary or a third secretary, because once his lawyers in the executive branch have identified a legal defect, here the absence of a presidential approval and a bid, he can't say, well, I think this contract is important to the interests of the state. It's not harmful. He has absolutely no discretion. His lawyers totally guide whatever he does, and he has to sign. He has no discretion, absolutely no discretion. Even though he's been elected by the people, he's making a public declaration of harm to the interests of the state. That's your testimony? That's your understanding of the law?
Articles 153 and 154 of the Political Constitution of the Republic do not exclude the responsibility of the officials and public servants. The legal advisors are part of that chain of responsibility, and they sign the legal opinions where they highlight the acts and actions that cause harm to the state. And in each of their opinions, they refer to the laws that are used as basis so that they cannot be used as conspiracy against the public, the President of the Republic, who is forced to sign a declaration of lesividad, but is rather a chain of responsibility based on the law. In addition to that, the effect of the declaration does not have an executive effect against the party, and as stated in the rule on checks and balances, the lesividad declaration forces the state of Guatemala not to use its power other than with a legal basis to be able to resort to the court. And that's the reason why Article 20 always states that all the actions have to be preceded by the declaration of lesividad. This is a stop for the authority, a break for the authority.
Would you agree that the President of the Republic is the premier figure in the executive branch? He
leads the executive. He's the head.
And so lawyers can make a decision on the ground of what is a defect in a contract and bind the President of the Republic to follow their recommendation.
Como le dije,
as I mentioned before, the chain of responsibilities includes the advisors, and this links, in particular, FIGUA's advisors to the Attorney General, the Attorney General, the legal and technical advisors with the Secretary of the within the office of the Secretary of the President of the Republic. Therefore, the President just receives a chain of responsibilities that are used for this decision. And also, a court of justice will verify whether that chain of responsibilities was based on the law, and the decision will be the one to determine whether the President and the advisors acted responsibly. If it was a responsible situation, there will be a decision that is favorable or positive to this. Otherwise, there will be a situation in which this decision will clearly show that the decision by the President and the advisors was wrong and against the law.
Mr. Aguilar, Mr. Gramajo told us earlier today, in fact, it seems like it was earlier last year. It seems been a long day. He told us earlier today that in his understanding, contracts 143 and 158 explicitly did not require the approval of the President. As you read those contracts, do you agree with Mr. Gramajo's interpretation?
En absoluto no estoy de acuerdo.
Absolutely not. I do not agree, because as part of the constitutional laws, Article 121 of the Constitution, subsection C, states that the assets that belong to the state include the assets of autonomous and decentralized institutions. Therefore, FEGUA's assets belong to the state, and any disposition of those assets require the approval of the executive, because the state does not usually award those assets as part of an usufruct, and the executive should approve any negotiation to that end.
I don't want you to misunderstand my question. What Mr. Gramajo said, to my understanding, was that the contracts on their face didn't require presidential approval. But after he came into his office, the lawyers in FEGUA said that it did, even though the contract didn't require it, that there was a requirement under Guatemalan law. That's my understanding. So I guess I'm asking you first whether your reading of the contract itself required presidential approval. Not whether the law of Guatemala did, but whether the contracts themselves required presidential approval on their face.
Si nos estamos
If we are referring to contracts 143 and 158, those contracts are null, absolutely null. They cannot be approved by the President of the Republic. This is different from what happened in Contract 41. And why am I saying that Contract 143 and 158 could have never been approved by the President? Because they were done in a covered way. There was no bidding process. There was no publicity of these. They were not made public, and it was a clear breach of Article 49 for public procurement of the state that orders the information.
FEGUA controlled that process, did they not?
It is not true. FEGUA's overseer assumed responsibilities that were not within his power, and the overseer is not and was not the government of Guatemala.
In your opinion, through the overseer, acted improperly or perhaps illegally by entering into that contract with Ferrovías?
En mi opinión,
In my opinion, FEGUA's overseer acted clearly illegally. These were personal decisions made by the overseer that did not represent FEGUA or the state of Guatemala. And let me elaborate. FEGUA's oversight that was decreed in 1976, approximately, rather 1982, meant that the overseer was going to have the powers of the management and the executive board. Therefore, for practical means, the overseer was the executive council and the management. But when we go back to the law, to the statutes of FEGUA, we see that neither the board nor the management have the authority to decide on the disposition of FEGUA's assets. FEGUA's law, Article number 3, states that their responsibility is to provide railway services. They have no authority to sell or rent or give their assets in usufruct. Therefore, Contract 143 and 158 were entered into by the overseer of FEGUA, but he was not representing the state or FEGUA. It was illegal.
I understand that you think he acted improperly, but he signed the contract with Ferrovias as the overseer, did he not?
And he signed them without legal powers. As a matter of fact, in the claim brought against Ferrovias by the state, there is a special section indicating that personal liability will be exempted to the overseer of FEGUA because of the legal actions.
Now, you mentioned that there were letter authorizations to try to correct this defect so that the equipment could continue to be used. Is that correct?
It was not too correct, but I think that I highlighted that the letters led to the breach of the agreement in Contract 41, and that's the reason why I referred to the terms. Contract 41, which was not approved, was signed on March 23, 1999. The first letter to breach what was agreed in the contract was directed by Ferrovias on April 9, 1999, barely 17 days after Contract 41 had been signed, and where Clause 6 had stated that the contract was going to enter into force 30 days after its publication. And even though this was well known, Ferrovias took possession of the equipment, and I also mentioned that they used the equipment without paying for its use during 3 years, except for the 7,500 quetzals that they paid in 2000. These letters were not to cure the defect, but they were a breach of the agreements stated in the bidding terms and also in the law.
More than one letter of authorization for Ferrovias, is that correct?
That is correct, and these letters were completely illegal, and they even modified how the payments were made, because the agreement in Contract 41 was the canon of 1% over gross invoicing, and letters dated 2002 that was changed to monthly payments, and it was estimated at 7,500 quetzales. There were several letters, one dated April 9th, April 12th, February 20th, February 25th, August 22nd, and October 3rd.
Why couldn't this whole issue have been resolved by just perpetual letters of authorization? If you say they were legal, correct? You think the letters from FEGUA were legal and gave Ferrovias the right to use the equipment? They could have just been used perpetually, couldn't they?
If I may just...
That is incorrect. That is incorrect. I never said that those letters were legal. Quite the opposite. I said that those are illegal and they did not authorize to legally use the equipment.
I may have misunderstood the translation.
The translation was wrong. On the transcript, he said the letter authorizations were completely illegal, but the transcript said completely legal. And that causes, I wanted to get that in before the
Because I thought that's what I heard.
The interpreter may have misunderstood the witness. I apologize.
Okay. So not only was 143 and 158 illegal, but these stream of authorizations were also illegal. Is that your testimony?
Es correcto.
And
That is correct.
it was FEGWA that was issuing these authorizations as well?
Sí, todos.
Yes. All started with a request by Ferrovias, and it was not FEGWA, it was the overseer, FEGWA's overseer, that was doing this illegally.
So this is Mr. Soseñas, I think, correct?
Es correcto.
That is correct, and Mr. Porras is also one of the persons.
He was just doing one illegal act after another, signing 143, signing 158, signing letters of authorization, all of these illegal, in your opinion?
Totalmente.
Absolutely.
Tal vez es importante que observen
It is also important for you to observe the date of August 13th of 2003, where 3 contracts are signed, 2 lease contracts for the equipment for 15 days between the overseeing of FEGWAS and Ferrovias. These are contracts that have no legal basis, and leases are set without no basis, and on the same day there is a term for 15 days to lease the equipment. Then that equipment is considered null, the amount is changed, and then as part of deed number 5, another contract is drafted for only 13 days of use of that equipment, just days before contracts 143 and 158 are entered into. So this is part of the legal actions used to dispose covertly of FEGWA's assets.
Just to understand your testimony, you're saying that because you consider 143 and 158 to be a nullity, that there was no way to remedy that, even if the president had said, I think that these contracts are the best thing since sliced bread for my country. There was no way in which he could have himself said, I'm going to sign the thing. If that's the problem, I'm just going to sign it. There's no way he could have done that. Is that your testimony? Under your understanding of the law, what you're instructing us on?
Sí,
Yes, it is correct. The President of the Republic cannot ratify a contract that originated against the laws of the country. It's impossible. But if we separate the contract from the right to dispose of the assets, the government can conduct any illicit negotiation as long as the laws of the country are complied with.
I have
I need to correct something for the I need to correct again for the record. Just the last 2 lines before Secretary Eisenstadt asked the last question, and the concluding lines of the expert, it says legal actions. He really said in Spanish illegal action. Again, is the opposite. But I think Secretary Eisenstadt follow up as if he had said illegal, but it's not what's on the record.
I mean, the distinction between legal and illegal in English is a pretty important one, and I'm sure it is in Spanish. What is the word? Why are we getting this continued?
Illegal.
Sorry, this is the interpreter. It's just because of the way it is pronounced. Sometimes he says he joins two words and the I in front of illegal sounds like and so you know it's just sometimes because of the way the words are put together, but the difference is very clear when the words are pronounced in an isolated fashion.
On these things, great acts can occur, so thank you for that. Two more clarifications. Do you think from your perspective that Ferrovias had any right to rely on the signature of the overseer of Ferrovias to 143 and 158 and then to subsequent authorizations by letter to use the equipment?
I'm sorry, but I did not understand the content of the question.
It didn't involve either legal or illegal, I can assure you that. So I'm asking you, did, in your opinion, Ferrovias have any right to rely upon the signature of the overseer of Fegway in 143 and 158, and then the subsequent letters of authorization to use certain equipment?
No tenía.
They did not have any right, and it is very important to state that in several letters, Ferrovias acknowledges that Contract 41 was not authorized. Ferrovias knew that they did not have a legal authorization to use the equipment, and they also knew that the use of equipment had to be approved by the President of the Republic, because that was stated in the terms of 1996, 6.4 of the bidding terms that were included in contracts 143 to contracts 143 and 158. Therefore, Ferrovias knew and accepted that only they could dispose of the assets with the authorization of the President of the Republic and the Council of Ministers.
Did FEGWA have any responsibility in this as well?
FEGWA's overseer does have responsibility, and it is so indicated in the proceeding started against Ferrovias in the country.
This question is, just to go back to the bidding issue, you mentioned that there were certain extraordinary circumstances in which a rebid could be avoided. You mentioned natural disasters and so forth. Are there any other exceptions to the general rule that public procurement contracts must be publicly bid? For example, if there's only one potential contractor, is that an exception?
No.
No. In public laws, there are different states that go from natural catastrophes, natural disasters, to other events that clearly define the exceptions.
It would be found in what part of the law? I know you memorized all of it.
En la ley de, no.
That would be in the law of public order.
Found?
Cuando ocurren
Whenever there are disasters and calamities, the Congress of the Republic so decides, or the President of the Republic with the Council of Ministers so decides, based on the level of the disaster and also the level of the number of purchases to be done as part of a bidding process, but these are exceptions.
No other exceptions?
No.
No.
We have no further questions, Mr. Horta, on the questions of the tribunal.
Thank you, Mr. Chairman. If we could put up R331. can you put a Spanish version too, or hand him a Spanish version? Oh, okay. We're just getting a Spanish version of this document for the witness. If we could just go to the first page just so I can identify it for the record, please, Kelby. Just go to the very top of the document and then we'll come back down. Just go to the beginning of the little... Just go back, I'm sorry, if you can go up a little bit. I just want to identify it for the record, please. All the way to the top. Yep, I just want to see the caption so that the tribunal understands what we're showing them. Okay. This, for the record, is Exhibit R331, and it is the complaint filed by the Attorney General of Guatemala before the Administrative Court regarding Contract 143 and 158. This is the English translation that's up on the screen. Now, if we could go down to the relief, all the way down to the relief sought by the Attorney General of Guatemala, and in particular, I'd like to highlight and ask the witness a question about numbers 5 and 6 of the petitions. Guys. No, 5 and 6.
3.
Apologies. It's only going to be a question or two. As soon as I get to this, then I'll be done. You're not able to find it? Sorry, while we're getting the English version up, to move this along, you have before you, Mr. Aguilar, a copy of the complaint that was filed by the Attorney General before the Administrative Court. Is that correct? You need to answer verbally.
Es correcto.
That's correct. That is correct.
Okay.
Es correcto.
That is correct.
And if you could look down to the petitions, the relief sought by the Attorney General, and in particular, numeral 5 and 6 of the relief sought toward the end of the document. Can you identify that, and please let me know once you've done that?
Is there a way I can see the English version? I can't.
Sí, lo encontré.
We're having
I found it. I found it.
this version up, Kevin, so what I'm going to do is I'm going to have the witness read what
I'd like to know what he's going to be asked about, so
Pero-
whether I can object or not, because I have a sense this is beyond the scope of the tribunal's questions.
It goes directly to the question that Secretary Eisenstadt asked about liability of the FEGWA overseer for the illegal acts committed. And there was a question answered by the witness about that, and he said that there was relief sought in the administrative court action regarding that illegality, and I would like to ask the witness a question about that. We will when we identify it, but as I mentioned, we're having difficulties getting the English version up on the screen, sir. Now, Mr. Aguilar, if you could, first of all, have you found the section where the Attorney General seeks relief from the administrative court? In the document?
Yes, I did.
Inform the tribunal what relief is sought in petition number 5 by the Attorney General?
En la petición número 5,
Petition number 5, the Attorney General's office requests the tribunal to rule on civil liability against the individuals that were involved in the negotiations that were declared lesivo.
What about petition number 6? What relief is sought there?
se-
A relief is sought for the legal costs and the costs cost under the contracts that produced harm to the state of Guatemala.
en mi versión en español, sí.
At least in the Spanish version it is.
What relief is sought by the Attorney General in petition number 6 of the administrative complaint that was filed by the Attorney General?
The petitions and reliefs go from number 3 to number 7. In number 3 is for things to go back to their original state, that is, to the state that they were in before the lesivo contracts were entered into, and that meant that Ferrovias should return the property and that the money be surrendered. That's petition number 3. Petition number 4 is for the payment of damages for the lesivo contracts. Petition 5 is for civil liabilities be declared against those who participated in the negotiations. Number 6 is that court costs and legal expenses should be paid by claimants. And number 7 is for a criminal court to be contacted if criminal activities have occurred. These are the petitions of the state of Guatemala in its action.
Mr. Stern.
Thank you. I think the record needs to be cleared up a little bit about these letter authorizations you've testified to. Isn't it true, sir, that these letter authorizations that you've testified to, there were no further letters were issued by FEGWA authorizing FEG's use of the equipment after Contract 143 and 158 were entered into?
That is correct.
The letter authorizations that were issued by FEGWA for use of the equipment were when Contract 41 was still there, right?
No.
No, they were granted by the overseer in an illegal manner, in a covert manner, and what was signed under 143 and 158 was illegal, and the letters of 9 and 12 April and February 2000 and August and October 2003 as well, 2002.
Dr. Gramajo, after he became FEGWA overseer and discovered the alleged defects in contracts 143 and 158, he didn't issue any additional letter authorizations to Ferrovias to use the equipment, correct?
I don't know what actions Mr. Gramajo did or did not do.
Well, but you aren't aware of any letters, authorization letters that Dr. Gramajo issued after he discovered these issues with the contracts, correct?
Sí, no.
Yes, I did not have before me any letter, nor do I have personal knowledge of that.
Let me ask you some further questions about the discretion of, or lack thereof, of the president to issue a lesiva declaration once receiving a recommendation from his advisors. Now, he was a lawyer, right?
Sí.
Yes, of course.
So if I understand your testimony, if President Berger, let's assume these facts, if President Berger had received recommendations from his legal advisors that contracts 143 and 158 were, in their opinion, lesivo, and President Berger took a look at the contracts and the opinion and said, you know what, I disagree with my advisors. I think they're wrong. As a lawyer, I think that they've got it wrong here. Is it your opinion that under those circumstances, President Berger would have had no discretion whatsoever to disregard his legal advisor's opinion and not issue the lesiva declaration?
Obviously, what I've said once and again is that if the president would have said that there is no lesivo, he would have issued a judgment, and that is something that can only be done by a court of law. The advisors have indicated defects, legal defects, and he has to issue the lesividad, because if not, he is personally civilly liable. Because if not, if he would have assumed powers that are powers of the judiciary, and that would not be correct.
Okay, so again, if I understand your answer, that means under my hypothetical that I just gave you, where the president, as a lawyer, looked at the contracts himself and said, I disagree with my legal advisors. I don't think these are lesivo. Under that circumstance, he still had to issue the declaration of lesivo, correct?
Vamos.
Let us not talk about the fact that he's a lawyer. According to the laws of the country, no one, a lawyer, an engineer, no one can ignore the contents of the law of the country. President Berger would have incurred liability.
Ignore the recommendations of his legal advisors, correct? No matter what.
Sí,
Yes, no matter what, because that is why we have courts of law. They verify or qualify during a legal action whether there was a violation of the law or not.
Is it your testimony that a breach of an administrative contract is always harmful to the interests of the state?
When there is a harm in a bilateral agreement, there is always a harm.
ahí ocurre.
And that is why we have principles of termination of contracts.
Okay, so again, when there's been a breach of an administrative contract, the government says the other side's breached an administrative contract. Under all circumstances, under Guatemala law, that is by definition harmful to the interests of the state. Is that what you're saying?
What I am saying to you is that any breach of a bilateral contract produces legal consequences. Those legal consequences may or may not be reparable. If they are, we are before this possibility of annulment. But if the defects cannot be cured, then one has to go to the courts, and the courts need to issue a declaration recognizing the absolute nullity. That is what I'm saying.
You testified earlier that when there's been a breach of an administrative contract, under all circumstances, the president must issue a declaration of lesividad before a suit can be brought in the administrative court, correct?
What I said was what I read out of Article 20 of the administrative law. Guatemala, whenever it wants to sue under a contract, needs to declare lesividad. That is what I said.
Breach a contract, it's always got to be declared harmful to the interests of the state. Is that what you're telling us?
Sí.
Yes, and that is based on estoppel, where the regulated party is protected, and the state has a limit, a time limit, to do this. This does not favor the state. It imposes burdens on the state because a private party can go directly to a court without any kind of declaration, prior declaration needed.
Now, you testified in response to Secretary Eisenstadt's questions about this issue about the notary and the registering the equipment under Contract 41. You recall that testimony?
Sí, lo recuerdo.
Yes, I remember perfectly well.
Show us where in your expert reports, either your first or second expert reports, where that's discussed, this issue about Contract 41 and the notary not properly registering the equipment. It's not in there, is it, sir?
No,
The question issued out of the reason why the state of Guatemala had not authorized it. It was the first question that was posed to me, and that is the answer and the conclusion that I gave.
Your expert reports, correct?
no.
No, because that was not part of my task. This was a question that was not only posed by the tribunal, but by someone else here today.
Okay, thank you. I have no further questions.
You've said quite eloquently that, in your opinion, the president can't substitute a decision which ultimately belongs to the court in terms of Lesivo. Is that correct?
Eh,
Yes, that is correct.
Does it give you any pause that the court here, 4 years afterward, hasn't acted at all, hasn't rendered an opinion?
In this specific case, are you asking about this suit?
My understanding is that we're now 4 years into this and the court's not yet rendered a decision. Does that give you any concern in terms of how this whole Lesivo process operates?
Hay varias,
There are several scenarios that are put forth in the law related to the administrative proceedings. The first scenario is the scenario called depuration by dilatory exceptions, and Ferrovias used these rights. It put forth a motion for lack of competence, lack of jurisdiction, said that the administrative court did not have jurisdiction. This suspended the normal course of the proceedings, and then the tribunal said that it did have jurisdiction to hear this dispute. During the evidentiary period, Ferrovias put forth 2 nullity actions, so this delayed the process as well. Ferrovias used its rights of defense. It answered the complaint, and if we look at a time parallel between what's going on here and what's happening in Guatemala, I don't see a huge difference. The process right now is at the state in which the court is ready to hand down a judgment.
Mr. Horta, on that question.
No questions, thank you.
Mr. Stern?
Mr. Aguilar, are you aware that Ferrovias' lawyer in the Contencioso Administrativo proceedings, excuse me, are you aware that Ferrovias' lawyer in the Contencioso Administrativo proceedings was told by a court official in October of 2011 that the reason the court hasn't issued its opinion is because of this arbitration proceeding you're testifying here today?
I'm not sure that accurately portrays Mr. Franco's testimony, but it is what it is.
Can you answer my question? Are you aware?
no tengo conocimiento.
I don't have any knowledge of that.
Creo que no hay más preguntas.
I don't think there are any other questions. Thank you very much to Mr. Aguilar for being here. You can step down. Thank you very much.
Sí. If I may have your attention, we will close for the day right now. We will resume tomorrow morning at 9. And also, if I may have the tribunal, the private word with all of you for a second.
Yes, sure.